in a poor country like ours, where people say corruption is eating us up. Those who give us aid, they tell us all the time that every year we can't account for 3 billion. That school that ought to have been built was not built because the money has gone into one individual's pocket and that person is not in jail. We had close to 112,000 girls who are supposed to be going to school, teenagers between not even underage. I mean, they are less than 16 or up to 16. And it is a crime that these people should be impregnated. That's yet they've been impregnated, and the people who impregnated them, we are not told about they facing any actions. You point to this in your memorandum.
Yes. Thank you very much, Samson, and good morning again. You were asking me to assess the relative importance.
That's right.
And for us as opponents of the bill, we believe that our advocacy is important because it safeguards and strengthens our democracy. In our memo, and I'm glad that you also pointed out that what people need to do is to read the bill and read the memos that are opposing what is in the bill. So we have set out our arguments quite well in the bill. We have raised the Article 108 unconstitutionality ground, and then we go into the bill itself and its provisions. And as you, I couldn't agree with you more what you said, the fact that more than half of the bill is spent on the memorandum. And then when you go through the bill, we are told that whilst in most bills, the interpretation clause is at the end in this bill, because it is considered necessary to put the interpretation clause at the beginning, and then you go into the actual clauses. So when you go into the actual clauses, you find that most of those clauses are repetitions of what is already in our Criminal Offences Act, with the exception that in some cases, what are misdemeanors in our Criminal Offences Act suddenly become second-degree felonies, and the punishments are doubled, which is already discriminatory, because if these identities that are being criminalized, if you happen to have one of them and you commit an offense, you can get double the penalty that quote unquote so-called ordinary citizens get. And then beyond the repetition and redundancy of many of the clauses, there is also the unconstitutionality, just the sheer unconstitutionality of many of the other provisions that are in there. So these are the grounds on which we oppose the bill. And in our own memo, we also, even the statistics that we cite, Samson, are more dire than what you have referred to about the spate of teenage pregnancy, abuse, sexual violence, so many types of violence that we would expect our honorable members to concern themselves with. So some of us were very much in favor of private members being able to bring bills, but we had hoped that they would bring bills that were in the public interest and according to the Constitution. So we're really disappointed. And in this, we see the hand of the World Congress of Families. And indeed, at least one of the sponsors of the bill has admitted as much on City FM about the role of this World Congress of Families, which suddenly now becomes the promoter of local cultures under which this bill is to be brought. Something I don't know if I have time to go into for me, the four main things that this bill, on the grounds on which this bill is founded. Do I?
Please proceed.
Yes. So there are four main grounds on which the proponents of the bill proceed. One, the first is on the ground of culture, that LGBTQ activity and related activities are not consistent with Ghanaian traditional and cultural values. The second ground is that it offends and threatens the sanctity of marriage. The third is that it is necessary to place restrictions on the basic rights of LGBT persons because rights are not absolute. And then the fourth is a public health concern. Now, if we go into these grounds that have been proposed, we find that indeed, Chapter 5 of our Constitution, which guarantees fundamental human rights, grants in Article 26(1) that every person is entitled to enjoy, practice, profess, maintain, and promote any culture, language, tradition, or religion subject to the provisions of this Constitution. Article 26(2) says all customary practices which dehumanize or are injurious to the physical and mental well-being of a person are prohibited. Further, in the directive principles of state policy, there are the cultural objectives of what the state should be. And we know that the Constitution is an aspirational document and that the directive principles are not justiciable. So under Ghana's Constitution, culture is not used to determine whether rights are allowable. Rather, culture is assessed on the basis of whether it infringes rights guaranteed by the Constitution. So the Chapter 5, which guarantees basic rights, makes no provision for the restrictions of rights on the basis of traditional Ghanaian customs, beliefs, and values. The second point I had made was about the sanctity of marriage. So when we look at Ghanaian law, LGBTQ persons are excluded from the institution of marriage. In an earlier program that I was on this week, I tried to make the distinction between sex and marriage, that sex is a private, intimate affair. Marriage is a public institution. The state has a legitimate interest in regulating marriage, in setting out the conditions under which marriage can occur. So when it comes to sex, the state's interest is in whether the person, the two people having sex, have capacity, have given consent, and also that it is private, that it does not offend public decency. Those are the three grounds. So for instance, adultery is against most people's public morality, but it is not a crime. It is not. The state does not deal with it. So if you like, the state deals with crime, the church deals with sin. And this week, so many people, including lamentably the president of the Catholic Bishops' Conference, they've been waving at us a decision of the European Court of Human Rights. It's a 2010 decision, by the way. That decision is not about the right of people to be gay. It's about marriage. It concerned an application by two Austrian men to the European Court of Human Rights to be married. And what the court said was that it was left to the individual states to regulate marriage. So this is being bandied around allegedly to support the fact that EU Court of Human Rights does not say the gay rights are not human rights. Please read, anybody who cares. You can go to the EU Court of Human Rights site. You can go to the BBC site. It's a 2010 decision. And as recently as July this year, the European Court of Human Rights was faulting Russia for not allowing any provision in its law for consenting gay people to be married. So it just reinforces the point that I made, that the state has a legitimate interest in determining who it will allow to marry and under what conditions. It does not get into the question of sex. So that is the issue around. So it is actually bizarre that people who are not even allowed to be married under our laws are precisely the people who are supposed to be posing a threat to marriage and family life. And one of the things that's in the bill, which is really strange, is that they provide very little evidential grounds for anything that they say. Nothing. There is really no research, except, of course, the false uses that they make of the research of the Ghana AIDS Commission, and of course of the findings of the CDD Afrobarometer survey. So the third ground that I stated was that no grounds are absolute. Of course, we know that rights can be limited, but the state, the Constitution sets out the grounds under which rights can be limited. And it is also important, Samson, to state in this discussion that under Article 33(5) of the Constitution, it says that the rights, duties, declarations, and guarantees relating to the fundamental human rights and freedoms specifically mentioned in this chapter shall not be regarded as excluding others not specifically mentioned, which are considered to be inherent in a democracy and intended to secure the freedom and dignity of man. In other words, the Constitution allowed that we are a growing state and that needs may change and new rights could be formed. So in 1992, when it was being formulated, it did not pretend that it knew everything, but allowed for this dynamism. So much of the comparison that is made about the restriction of rights goes to the Vigilantism Act and the Cybersecurity Act. And it is important to distinguish that in both of these, we're talking about national security. We're talking about harms. So, and it is clear, we know the violence that characterized the 2016 and 2020 general elections. So nobody disputes the necessity for criminalizing vigilantism. So, or the Cybersecurity Act, on the grounds of national security. But the anti-gay bill provides no such public interest grounds for restricting rights to privacy, to free expression, to personal autonomy, non-discrimination, association, etc. It's interesting, at the beginning, you had the Attorney General talking about advocate against. Advocate against does not mean legislate and criminalize, okay? Now, the last thing about the public health concern, and again, so 18.1% of men who have sex with men were found to be HIV positive, which means that the almost 82% of HIV persons were heterosexuals. So it actually does not support anything on this public health thing. So all the things about how much money we spend, etc. I think that you have cataloged the litany of waste in our system. So to really focus on some people on these grounds are spurious, extremely spurious. And that is why we said that really there was nothing, that already some of the provisions, and I could go on and tell you those clauses 7, 8, 9, 10, 19, 20, are already provided by the Criminal Offences Act. But in most cases, we find that because this bill is so punitive, it goes ahead and doubles the punishment. And then we have clauses 12, 14, 15, and 16, which are patently unconstitutional. In fact, as academics, when we argue, when we debate according in a logical fashion supported by facts. We do not allow our emotions to override us. I just sent a message to Professor Piaget to ask him, who was the chairman of the Constitutional Review Commission, 89% of all submissions to the CRC was on the issue of homosexuality. That's incredible. In any case, the government, let me finish. The CRC, let me finish. Sorry. We have a host.
Okay.
Yes. So the CRC report was read in its entirety by the government, issued a white paper. In any case, none of the recommendations were even implemented. And in what you read, you were talking about tolerance. In the African Charter on Human and People's Rights, they also talk about individual rights. Individual rights. And the African Court of Justice has voided a number of provisions in national laws precisely on those grounds. So I really think that we should not substitute our private emotions or our religious views in making legislation.
All right.
And let me go specifically to the 18.1%. I also read the report, and I know that the two highest groups that had HIV prevalence was men having sex with men and commercial sex workers. And it was because of multiple partners. So it was not just about their orientation.
Okay.
And what is proposed in the bill will make the situation worse because it will drive people underground, as has been shown in various places. So we can take any statistic, even the CDD report, the Afrobarometer report. At the end of it, the thing was not to legislate the intolerance of the 93% of people, but to protect the 7%. So this legislation will actually embolden. That is why yesterday we had an NDC communicator saying, stone and kill gays and lesbians in your communities. This from a party. If you go on the website of the Progressive Alliance, the NDC is a member of the Progressive Alliance, and one of its aspirations, goals, is about promoting gender and LGBTQI rights. So I would urge that the party look at its own associations so that you have a social democratic party that is now promoting this hateful legislation. So does the NDC have one face at home and another face abroad? I associate myself with many of the points that Dr. Opoku-Edusei made, and to respond to a couple of points. Last week, Honorable Sam George was purporting to tell us what we could teach as intellectuals in our classrooms. I think on this same program, this is a huge infringement of academic freedom and really a restriction on critical thought, which is the hallmark of an academic. An academic is not just somebody who teaches in a university. It's somebody who espouses critical thought and engages on the issues. In our memo, we did not make any demands. We were responding to the bill that has been put before us. Honorable Dafiamepo, I'm your senior by many years. I just want to remind you, okay, I was called to the bar in 1977. So when you call senior Akotoampa, I'll call senior men too. But in any case, I've heard you telling me what I should do with my children, which is really, really, for a member of parliament faced with a bill. I was so disappointed. But the reason why you say we use language, when you use language like recant in a bill before parliament, what is it reminiscent of? That is why we were referring to the Middle Ages, okay? So your clause 22, if the person will recant and accept treatment, then they don't go to prison. I mean, what kind of state do you live in? Are you the Taliban? Now you mentioned the Road Traffic Amendment Act. And here again, we see the hand of the World Congress of Families. We are talking about the right of unborn fetuses. Isn't that incredible? Isn't that incredible that of all the rights to be protected, it is that of unborn fetuses? Your Article 108 submission, the opinion of the person presiding. The person is a referee. This is the same person who has promised, even before the memos are considered, that the bill will be passed by the end of the year. The procedural ground can be raised at any time, even after the bill is passed. So because you are saying that it is a future, so if you don't raise it and then it imposes all these charges because you did not raise it, it becomes constitutional. No.
All right.
The issue about artificial insemination and Professor Ajechi's views. I would advise Professor Aka to go around the fertility clinics in Ghana, where a lot of artificial insemination is taking place. So this view that, you can only do certain things a certain way is old-fashioned. It does not accord with people's wishes. Not everybody wants to have children. Not everybody can have children. So what are you going to do now with women who cannot have children, men who are impotent? How do they threaten the sanctity of of the family.
Okay.
We're not talking about legalization. We're talking about your criminalization.
All right.
And I hope you paid attention to the distinctions I made between sex and marriage.
Thank you.
What the state.
Thank you. Thank you so very much. Of course, this subject